retainer counsel for opposite party number 2.
Lordship, this may be taken any day, Lord, after 1 week of Your Lordship convenience, Lord. Today I
Appropriately, whenever the bench is, as and when the bench is constituted.
much obliged, Lordship.
Item number 2. Review number 1 for 2021. Mr. Samir Kumar Lal for the petitioner. Mr. Rajiv Sinha for the Mr. Rajiv Sinha for the opposite party.
But in these case notes, I am praying notes 4 weeks time notes for removing surviving defects, and notes I also seek permission to correct some typographical error in some certain pages notes. Though that was not pointed out during stamp reporting, but notes I could learn later on that some typographical mistake is there in notes certain paras notes.
No. For that, you will have to file a supplementary affidavit.
Yes, then notes I will be filing the supplementary affidavit for that also notes.
4 weeks time as prayed for is allowed to learn counsel for the petitioner to remove the following surviving defect and also file supplementary affidavit to remove the typing errors in the relevant paragraphs of the petition.
Much obliged.
For orders, item number 3. Civil review number 40 of 2021 of Rajita Sinha for the petitioner. Mr. Gautam Matis for the.
Yes, my lord. I am filing the review petition, my lord. So far review the last portion, prior portion of the relief portion, which has been mentioned in the judgment dated 4/2/2021. That is page 53 to 54. But today, my lord, the IA petition is before your lordship. That is so far subsistence allowance is concerned. Kindly turn the page for 54 of the civil review.
Yes.
Yes,
Who is appearing? Mr. Gautam Rakesh?
Yes, Your Lordship, I am appearing.
but only because there is no mention that subsistence allowance be paid with the liberty, while the daily portion is that the purpose of conducting regular inquiry on the alleged charge, the authority management shall have the liberty to proceed the disciplinary inquiry by placing the petitioner under suspension. They have put me, the reinstatement order has been passed, the judgment is 4/2/2021, and reinstatement order has been passed on 19/3/2021. On the same day, 19/3/2021, page 33, the suspension order has been passed. I have annexed it in my IA petition also, page 14, my lord. Can you see that?
Can we entertain the IA? Because if the review is maintainable, then
My lord, so far, my lord, there is no law to deny the subsistence allowance. Rather, it is for survival. Therefore, if they say that yes, there is nothing mentioned in the order, they may put under suspension but no relief. Then I may be face the consequences of even not denied the
that's a
subsistence.
separate cause of action. That for that a separate writ petition would have lied.
My lord, how, my lord, kindly consider the relief portion. The relief portion, it has been stated that is implied the subsistence allowance when a person is put under suspension. There is a Supreme Court judgment on that point. I have given the copy also. My lord, consequently, the petitioner is reinstated to the service only for the purpose of conducting regular departmental inquiry on the alleged charges. The authority and management shall have the liberty to proceed with the departmental inquiry by placing the petitioner under suspension. If the competent authority to the respondent may issue a charge sheet within a period of such and such and receipt of the order and conclude the proceeding in accordance with law as especially as provided preferably within a period of 6 months from the initiation of the departmental proceeding. I raise, madam, what is the necessary to say that pay the department subsistence allowance? When that kindly rule, I have given the rule also, kindly consider it. In case of departmental inquiry proceeding, deemed suspension, I am entitled according to the rule also and according to the established law also, no man can face the consequences only because he is in suspended, he is not paying the subsistence allowance. That is a
So
new
first
case,
of
and
all, if there is no error apparent on the record and whatever is the ground you are raising for seeking review is an appealable ground, we will not entertain the review petition.
my lord, kindly
You say
consider
that
the what
it
that is
has
some.
not allowed back wages for the intervening period.
Then also I
The
am entitled for the
clearly says
subsistence.
that depending upon the outcome of disciplinary inquiry, while considering the issue regarding consequential benefits, DA may keep into mind so and so law.
That's why
So
I am
the
challenging it, my lord,
already
because
given.
my lord, kindly consider that is against the established law, that is 2013-10 Dipali Guddu's case, as also railway rule. I have given the
Challenge,
rule, my lord, hard copy, that
challenge
the
the
rule.
judgment on that ground in an appeal.
My lord, kindly consider the rule was not provided before your lordship. Judgment was reserved, and after that the judgment was passed. In the judgment also, Dipali Guddu's case has been mentioned, and so far the two cases are Vishwanathan Pillai. The caste certificate was false, therefore no necessary was to proceed inquiry proceeding. In my case, it has been held. It is in violation of the 311(2) because no charge sheet was issued and such and such. And so far the ECIL case, my lord, that is also de novo inquiry. There is distinction in between the de novo inquiry and the fresh inquiry. In my case, there was no charge sheet, no inquiry proceeding, only by virtue of the High Court's order, and they can put me under suspension. They can proceed departmentally. I have nothing to say because the charge has to be proved. Then, in my case, my lord, there is no de novo inquiry. That is, a first charge sheet has been issued. I was dismissed from service in 2012, and now I have been reinstated when my dismissal order has been held illegal and contrary to the rules of the natural justice and also 311(2). What will be the position, my lord? Railway rule also says so. I have given the hard copy of the rule. If your lordship kindly see me. In my case, only while a direction may be given to give the subsistence allowance. After that, if your lordship say they hear the matter of the civil review, if it is not allowed, then we shall proceed whatever may be. Dismiss.
Mr. Gautam, where is the fight about not paying subsistence allowance or paying subsistence allowance? If the court has indicated that you can place him under suspension, subsistence allowance is a thing without asking also.
Lordship, in Annexure 3 with the IA, there is no denial of payment of subsistence allowance.
I have given that in the petition. I have
No,
not
no.
paid for 9 months.
Right, but it does not specifically say that she will not be entitled to payment of any subsistence allowance.
Nothing has been said, but they have not given me.
So
And on the plea also, my lord, they have not
you
written.
represent before them for payment of subsistence allowance.
My
They have
lord,
not denied. How do you say that they have denied?
my lord, my lord, survival is necessary. There is a decision of the Honorable Supreme Court. Denial of the subsistence allowance is amounts to slow poison.
There is no
How?
denial by Annexure 3.
If no response has been given, no reply, not paid, what is the meaning stand? I may put a question to myself.
Not, no.
That is the March 2021 I have put under suspension. Nothing has been recorded. And
You file
till
a
date,
reply to the IA,
yes,
Mr. Rakesh.
yes,
Your Lordship, my submission is that this review petition itself is not maintainable. After hearing
Very well.
the whole merit of the case, order was
Reply. We are not asking you to file a reply to the review petition. That we will entertain on our own understanding of the grounds raised. But so far as the IA is concerned, you file a reply.
Or you make it infructuous. Or you simply say that you are willing to pay the subsistence allowance.
yes, according to the rule. Rule is there. I have quoted.
They have also represented before you. You do whatever.
Mr. Gautam Rakesh, Learned Counsel for the Respondent Railways, is allowed 2 weeks time to
name
file
of
reply.
Mr. Mahesh Tiwari may be.
how can we name councils who are not on record, not appearing in person?
Okay, Your Honor. Yes, Your Lordship.
2 weeks time to file. Reply to IA number 7306 of 21. List the case after 2 weeks, as and when the bench is formed.
Much obliged.
Item 4, CMP number 149 of 2021, Mr. Express for the petitioner, Mr. Prashant Polo, for the list.
Yes. Defects have been removed. Yes, Mr. Gautam, unmute yourself.
Lordship, there was some network issue. Lordship, am I audible now?
Yes, yes.
Lordship, all the defects have been removed, Your Lordship. There are no surviving defects in the CMP, Your Lordship. Lordship, this is for restoration of WPS number 3515/2019, which was dismissed for default on.
Opposite party. It was dismissed due to non-removal of defects or what?
Yes, non-removal of defects. There was a preemptory order, Your Lordship.
Okay. Third learned counsel for the petitioner, Mr. Shreyas Gautam. This petitioner seeks restoration of WPS number 3515 of 2019, which was dismissed for default due to non-compliance of the preemptory order dated 28th May 2020. By not removing the surviving defect within the stipulated time. Stop. When counsel for the petitioner submits that the due to COVID-19 pandemic, the supplementary affidavit required to be filed was delayed. Stop. Petitioner could not come to swear the affidavit as department was sealed on account of the employees getting affected by corona. For the reason that the employees had got affected by corona. It is submitted that the petition may be taken up on merits by restoring it, otherwise petitioner may suffer irreparably. It is further submitted that the same impugned order has been challenged in WPS number 3. What is the other writ petitions number?
If I'm not wrong, it is 7311 of 2019.
Give the correct number to the.
I will ascertain and give it to you.
By the private respondent. Stop. We have, on consideration of the explanation and the submission of the petitioner, writ petition number so and so, and on being satisfied thereof, writ petition number so and so is restored to its original file, subject to payment of cost of rupees 2000 in Jhalsa within 2 weeks.
Lordship, my appearance is recorded on behalf of Union of India.
You are Mr.
Bajrang Kumar, AC to Mr. Prashant Pallo.
Bajrang Kumar,
Yes, Lordship.
AC to AAG, Mr. Prashant.
Obliged.
Obliged, Lordship.
Let the writ petition be listed along with that other writ petition.
Yes, sir.
See if any. There is some surviving defect in the writ petition.
Lordship, the supplementary is required to be filed, Your Lordship. I'll be filing it in the meantime, Your Lordship.
And the surviving defect in the writ petition, restored writ petition be removed before that, within a week.
Yes, Lordship.
Very well, sister.
The angle has changed today.
Actually, the live streaming of these court proceedings are going on.
Okay.
So a small camera has been kept here, and on the physical day, since the counsels were appearing, therefore the screen has been kept on the right side. And whenever I have to look towards the counsels today, I have to look on the right side as I am doing now.
Okay. And for the division bench live streaming, only your lordships are visible, or the?
No, both of us are. This camera in front of our this table is, and
Different
in
setup.
the counsels are also visible. There is a camera which faces the counsels also.
Okay.
So, and our court live streaming has started for all 5 days.
Okay. Okay.
Okay. Yes.
May it please, His Lordship.
On the daily constitution, item 15, WPT number 327 of 2020, because Nitin Kumar Prasad from the Commission, and the Rasan of Lamin for the
Because the challenge is to DRC 07, which has been issued, annexed at page 62.
Yes, a connection. Yes.
Because the challenge is annexure 12 at page 62, as also the challenge is to the blocking of input tax credit available in my electronic credit ledger. Look, the facts of the case are not in dispute. Let's only one thing I wanted to point out. Let's, if I can just give few dates, my lords.
Yes.
Well, it's the petitioner is a works contractor and is having a JV with ONGC and IOCL for exploration and production of methane gas from the coal bed melons.
Yes.
While the petitioner is under the stage of establishment, on 1/12/2018 an inspection is carried out, and on the basis of section 71, the documents are sought for from us. The documents are furnished within 15 days thereafter, and pursuant thereto, after we gave the details, on 22/7/2019, DRC 01 and DRC 02 is issued, which is at page 60. If my lords may take up page 60 for a moment. The type copy is also there. Annexure 10, page 60.
Yes.
Now, this is a summary of show cause minutes. There it's in two parts: GST DRC 01 and GST DRC 02. Both issued on the same day. The heading is summary of show cause notice issued under section 73.
Yes.
What they say is आपके द्वारा आरोपित GST 3B के माध्यम से अवेल्ड ITC की राशि ऑटो पॉपुलेट GSTR 2A की राशि से अंतर परिलक्षित हो रहा है का ब्यौरा निम्नवत है. And then they carry out the calculation and they want to impose tax penalty interest on the basis thereof.
Yes.
And minutes thereafter, minutes at page 61.
Yes.
This is for the period, minutes page 60 is for the period 17-18, July 2017 to September 2018 months.
Yes.
And then at page 61, annexure 11 minutes,
Yes.
GST ASMT 10 is issued under section under section 61, rule 99(1) of the act and the rules. Now I want to place the last paragraph of this page 61. You are hereby directed to explain the reasons for the aforesaid discrepancies by 5/8/2019. If no explanation is received by the aforesaid date, it will be presumed that you have nothing to say in the matter and the proceedings in accordance with law may be initiated against you without making any further reference to you in this regard. Now, but this is palpably wrong in view of section 61. If my lords may take up section 61 for a moment.
Yes.
Minutes, I have sent a compilation. It is there in the compilation as well. Minutes, page 13 is relevant.
Yes.
Minutes, may I place section 61 minutes? Because
Yes.
ASMT GST 10 is issued under section 61. May I place it?
Yes. Yes.
The proper officer may scrutinize the return and related particulars furnished by the registered person to verify the correctness of the return and inform him of the discrepancies noticed, if any, in such manner as may be prescribed and seek his explanation thereto. In case the explanation is found acceptable, the registered person shall be informed accordingly and no further action shall be taken in this regard. In case no satisfactory explanation is furnished within a period of 30 days of being informed by the proper officer or such further period as may be permitted by him, or where the registered person, after accepting the discrepancies, fails to take the corrective measure in his return for the month in which the discrepancy is accepted, the proper officer may initiate appropriate action, including those under section 65, 66, 67, or proceed to determine the tax and other dues under section 73 or section 74. Now, in this case, after ASMT 10 has been issued, well, straight at page 12, DRC 07 has been issued at page 62.
The
It's page 62.
ASMT 10 is at page 61.
Yes, my lords.
It's a reminder. So earlier notice must have been
It is
sent.
not on my web portal. It's not on my portal, my lords.
Which one? The earlier one.
The earlier one.
So this one is 27 July. And
And if my lords would see this notice, 27/6 was there initially. They have striked it, and then they have made it 22nd July, 27th July. And the reference number also has been changed accordingly.
History of 3D2A.
And then at page 62, DRC 07 is issued.
The very question then comes up in this matter, whether ASMT 10 is a precondition, but you say that SCN under this section 73 was issued on 14 December 2018 itself.
That was issued on 22nd of July 2019.
Okay, 20.
That is at page 60, my lords.
There are two dates. What is the first date about?
The first date is 22/7/2019.
No, just above that in the DRC 02.
Yes, my lords.
4th December 2018.
4th December 2018, my lords, that was after the inspection. The inspection is carried out on 1/12/2018.
That is no. How do we decipher that? That is in relation to inspection.
That is if my lords would see the first inspection which took place at 35, the page 35. If my lords would see for a moment.
35.
Page 35, my lords.
That is completely illegible.
The type copy has also been given.
And typed copy gives a date of 1st December 2013.
That's a typographical error, Mills. It's first September, December 2018, Mills.
That is 1st December. You should have seen that, no? You have certified it to be true copy.
Mills, that's my fault. Mills, I stand corrected, Mills. At page 36, the last paragraph. If may I just place it, Mills? जिसे उपस्थित व्यक्ति द्वारा अहमदाबाद के हेड ऑफिस में संधारित रहने के कारण तत्काल उपस्थापित करने में असमर्थता प्रस्तुत किया, यह झारखंड माल एवं कर अधिनियम 17 की धारा 35 एवं 36 के अनुरूप नहीं है। अतः व्यवसायी को झारखंड माल सेवा एवं सेवा कर अधिनियम की धारा 71 के अधीन दिनांक 4/12/18, दिस शुड बी 4/12/18 अगेन मैनेज, को समस्त लेखा पुस्तकों के साथ राज्य कर उपायुक्त दक्षिणी अंचल के कार्यालय में समय 11 बजे उपस्थित होने का निर्देश दिया जाता है। And based upon this inspection and the notice issued under section 71, page 60 has been issued.
True, yes.
And after page 60 is issued,
yes,
well, it's page 61 is the ASMT.
So that is what we are asking, whether issuance of ASMT 10 is a precondition for issuance of notice under DRC 02.
Then in that event, Melits may refer to again section 61, subsection 3.
Yes.
So if a proceeding has to be initiated against me in terms of section 61, I say I fall under section 61(3) because I did not file a reply. So there is no question of there being any satisfactory reply. So if at all they wanted to carry out any proceedings against me, and since their notice is under section 73, so the proper show cause notice is not there, which my lords have decided in NKS and today also, my lords, in BLA projects case.
No, DRC 02 gives an indication of the contraventions.
Correct, my lords. Correct.
अंतर परिलक्षित हो रहा है 205.69 लाख है टोटल ऑटो पॉपुलेटेड 123 है.
Correct, my lords. There is a difference of 82.5 lakhs.
Yes.
Now that is why I wanted to refer to that again at page 61. Page 60 is for the period July 2017 to September 2018.
Yes.
And then ASMT 10 is issued for the period 18-19. So there are overlapping periods, my lords.
Yes.
Now against this, let me assume, my lords, that I am at fault. The dispute is with regard to mismatch. I have availed the input tax credit of 205 lakhs. The auto population was only 125 lakhs. So that is the difference. So if there is a mismatch also, in that event, why I say NKS comes to my rescue, only one paragraph I'll refer to in NKS. In that case also there was an allegation of mismatch. Paragraph 11 at page 2659 judgment. Paragraph 11.
This is part of your compilation at page.
It's a part of my compilation is only the first judgment which was delivered by my lords. That starts from page 21.
Yes.
And the relevant is at page 13, my lords.
30.
Paragraph 13 at page 26, my lords.
Yes.
Now, if my lords would see, the notice my lords had quoted in this case also,
Yes.
although it was in the notice was issued under section 74, but my
Yes.
lords have quoted the same.
Yes.
And it has been, and that has been dealt with in paragraph 13, my lords.
Yes, please.
A bare perusal of the provision indicates that in a case where it appears to a proper officer that any input tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of facts to evade tax, he shall serve notice on the person chargeable with tax which has not been paid or has been short paid, or to whom refund has been erroneously made, or who has wrongly availed or utilized input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice, along with the interest payable thereupon under section 650 and a penalty equivalent to the tax specified in the notice, and so on, Mills.
Yes.
Now, let's in my case, what has happened? Well, it's GST being a new act, there were a lot of dealers who were not filing their returns timely. And that is why, well, it's a notification was issued at page 39. At page 39, minutes, order number 2 of 2018, dated 31st December 2018.
Page 39 of the writ petition.
Yes, Manoj.
Yes.
May I place it, Millets, in totality, Millets? Whereas subsection 4 of section 16 of the CGST Act provides that a registered person shall not be entitled to tax input credit in respect of any invoice or debit note for supply of goods or services or both after the due date of furnishing of the return under section 39 for the month of September following the end of financial year to which such invoices or invoice relating to such debit note pertains or furnishing of the annual return whichever is earlier. And whereas subsection 3 of section 37 of the Act provides that any registered person who has furnished the details under subsection 1 for any tax period and which have remained unmatched. So this is a case of mismatch. Under section 42 or section 43 shall upon discovery of any error or omission therein rectify such error or omission in such manner as may be prescribed and shall pay tax and interest, if any, in case there is a short payment of tax on account of such error or omission in return to be furnished for such period, provided that no rectification or error or omission in respect of the details furnished under subsection 1 shall be allowed after furnishing of the return under section 39 for the month of September following the end of the financial year, to which such details pertain, or furnishing of the relevant annual return, whichever is earlier. And whereas the financial year 2017-18 was the first year of the implementation of the goods and services tax in India, and the taxpayer were still in the process of familiarizing themselves with the new taxation system, and due to lack of said familiarity, the registered persons eligible to avail input tax credit could not claim the same in terms of the provisions of section 16 because of missing invoices or debit notes referred to subsection 4 within the stipulated time. The registered persons could not rectify the error or omission in terms of provision of subsection 3 of section 37 within the stipulated time, as a result whereof certain difficulties have arisen in giving effect to the provisions of subsection 4 of section 14 and subsection 3 of section 37. Now, therefore, look, this is important. In exercise of the powers conferred by Section 172 of the CGST Act, the central government, on recommendations of the Council, hereby makes the following order to remove the difficulties. Namely, this order may be called the Central Goods and Services Tax Second Removal of Difficulties Order 2018. In subsection 4 of section 14 of the said Act, the following proviso shall be inserted, namely, provided that the registered person shall be entitled to take input tax credit after the due date of furnishing of return under section 39 for the month of September 2018. My case falls under this. Till the due date of furnishing of the return under the said section for the month of March 2019 in respect of any invoice or invoice relating to such debit note for supply or goods or services or both made during the financial year 17-18, the details of which have been uploaded by the supplier under subsection 1 of section 37 till the due date for furnishing the details under subsection 1 of said section for the month of March 2019. In subsection 3 of 37 of the Act, after existing proviso, the following proviso shall be inserted. Provided further that the rectification of error or omission in respect of the details furnished under subsection 1 shall be allowed after furnishing of the return under section 39 for the month of September 2018 till the due date for furnishing the details under subsection 1 for the month of March 2019 or for the quarter January 2019 to March 2019. So now what was happening, Millets, that until September 2018, any registered dealer, be it a supplier or be it a recipient, if has not furnished the return and if there is a mismatch, that time was extended. And in my case, I had furnished my return in terms of the purchases carried out and the invoices available to me. But since my supplier had not furnished their returns, so hence there was a mismatch. But after this notification came, my suppliers also furnished their returns, and that I have annexed with my rejoinder minutes. With my rejoinder, if Milots would see, I am sorry, Milots, with my writ petition itself, at page 67 onwards.
So all this you demonstrate in an appeal before the authority.
Now that is why, now the question would come that why did I file the writ petition? Well, it's when this GST DRC 07 was issued, well, that is annexed at page 62. At page 62, this DRC 07 was issued, no order was passed. Only this was there. No order was communicated to me, not uploaded on my web portal also. Only page 62 was there on my web portal.
Then
And thereafter, immediately, plus being a bona fide SSE, at page 63, annexure 13, we filed DRC 08 in terms of 161.1. 161.1. We filed an application because that was a right available to me.
for rectification.
Yes. And I filed it on 28/9/19 within 10 days. The Act provides 90 days time, 30 days time. I filed it within 10 days. Now, after this filing of rectification application, till date, no order has been passed, no hearing has been carried out, it has not been rejected. For the first time in counter affidavit, they take a plea that since 6 months have lapsed after the date of filing, we cannot do anything. Second, they have said that there is no error or omission or arithmetical error for which a rectification can be carried out. Now, what they are trying to do is they are trying to equate the provision of review and rectification. Which is not the scheme of the Act, Manoj. That is what I wanted to point out. Now, because the reasons I approach this Honorable Court, having filed a rectification, until and unless any order is passed, I cannot maintain a simultaneous proceedings before the lower authorities. Secondly, pending my rectification application, they blocked my input tax credit also, and which I have annexed to my writ petition. At page 71, 74 lakhs, they attach minutes. They block my input tax credit. Page 71 minutes. Now, all that they have said in the counter affidavit and the supplementary affidavit, in the counter affidavit, I do not know if at all this officer is a responsible officer or not. If Milots may see their counter affidavit for a moment. Their counter affidavit, Milots.
Yes.
Let's at page 17, they have annexed the entire order sheet. Yes. And how manipulations have been done in the order sheet, if Milots would see. Page 17 onwards.
Yes.
It appears that the entire order sheet has been drawn on a single day, just in order to render my writ petition infructuous. 1/12/2018, they initiate the proceedings. Next date fixed is 4/12/2018, and they say व्यवसायी द्वारा सूचना के अनुपालन में कोई कार्रवाई नहीं की गई, अतएव दिनांक 3/12/18 they cut it, and then again let's make it some other date which is not apparent which date they fixed. The next page, if my lords would see, it's a white sheet. It's a plain white A4 sheet, my lords. The department never uses a white sheet, my lords. There is a buff sheet, proper order sheet which is drawn, my lords. As would be evident from page 17, it's a continuation. No white sheets are used, ever. At least, my lords, in 21 years, I have never seen.
Have you specifically denied that on the dates on which you have been shown to have appeared and filed your Hajri, etc., and documents, you actually were not in notice of those dates?
Well, it's whatever dates were there, I have annexed the documents, my lords. That apart, there was no other notice.
On oath, dates
Yes, my lords.
regarding your appearance and submission of documents as indicated in the order sheet at page 17 onwards, Annexure C series, has this been denied specifically, para 10?
My lords, at page 40, my lords, my rejoinder,
14.
if my lords would see paragraph 45 and continuation 46. Page 16, paragraph 45 to my rejoinder, my lords. May I read it, my lords?
This is what you have already said, but whether these dates there was no appearance from your side and no submission of documents, that you have denied, that you haven't denied.
No, my lords, not in specific words. Not in specific words.
If that was the case, that there had been no dates on which any such proceedings were being carried out, and it is a manufactured order sheet, then you
Well, that we have said at page 17, if my lords would see for a moment, at page 17 of my rejoinder.
that regularity of
Paragraph
official
56.
we will presume, unless you specifically demonstrate that there were no proceedings on that date. You never appeared on that date. That is an inquiry on facts about a statement made in a court, and especially the High Court, on oath.
Well, it's paragraph 46. Well, whatever I have said, it's a perusal of the order sheet annexed to the counter affidavit appears to be drawn on the same day, in as much as there is no variation in the flow of the handwriting, save and except different pen used by different authority concerned, and the
30 जनवरी 2019 व्यवसायी द्वारा आईटीसी से संबंधित कागजात प्रस्तुत किया गया आंशिक जांच
well, that we have myself annexed. We have ourselves annexed, my lords.
So then,
We have annexed.
Then in that case you have appeared on that date.
Minutes annexure 7, 8, and 9. Annexure
Yes.
7, 8, and 9. There is no denial, minutes. Minutes. All that I am trying to say that the order sheet which has been annexed.
No, that we will not simply go on presumption.
Look, assuming against me, minutes. Assuming against me. Assume against. Look, everything against me. In that event also, minutes may take up my compilation for a moment, minutes.
You assail all these things in an appeal because there are too many questions of fact and which are being disputed by you, and they have annexed an order sheet which shows that you were on notice and appearing and participating in the proceeding. So whatever you have to say, both on facts and in law, the appellate authority should consider.
My lords, fair enough. Fair enough. So far at that aspect, if my lords would want, my lords would say, I will not say much. But so far as blocking of my ITC since February 2020 is concerned, that is against the principles,
That
If my lord sees the notification we have annexed, my lords,
that they will decide within a time frame and
there is
unblock.
no question of any decision, my lords. When
No,
the
no.
act,
When you go to the appellate authority, the court will ask them to take a decision on the question of unblocking because it is in teeth of 86A3.
my lords, if only I can say, my lords, that there is a violation, there is a standing order, there is a notification which is absolutely against them. In the counter affidavit, they are saying that we are taking steps, but that too, it has been more than 2 weeks.
True, you see, in the course of your argument, if I may summarize, you mean to say that you didn't get in fact, you replied to the ASMT 10, which remained unresponded, and DRC 07.
No. ASMT 10, I have never replied.
This is what you say that within DRC 07, you have asked for a record.
Yes, my lords. Yes, my lords.
Okay. So after the ASMT 10, you got an opportunity to reply, seek, supply your reply, but you didn't. And thereafter, DRC 07 came in September. This is of July.
Yes, my lords.
So you did not respond to the notice of discrepancy.
That is why I said, my lords, I assume everything against me. But section 61 and rule 99 cannot be given a go by. I'll read section 61(3) for a moment once again, my lords.
No, we have read that. The date of ASMT 10 is 27 July.
Yes, my lords.
Asked to
Which they say is a reminder.
Explain by 5th of August 2019.
Yes, my lords.
The RC07 is issued on 18th September 2019 in respect of a proceeding which was being carried on since 2018 December itself, as it appears from the order sheet and also the first notice to you to produce the documents. So
Yes,
ASMT 10 scrutiny was going on parallelly maybe, and DRC, this section 73 proceeding was going on after they carried out an inspection and issued a notice to you to produce documents, and thereafter issue notice under DRC 01 and under DRC 02. So DRC 02 notice gives a picture of the contravention committed by you, and after that you have participated in the proceedings.
After 22/7, we have not participated.
No, maybe, but before that you have been participating and tried to show. So in that case, all these things are some involving a maze of facts which are not wholly undisputed.
Let's only one thing. Let me put it this way. If my lords may take up for a moment my rejoinder, my lords. Page 19, Annexure 16, my lords.
Page 19.
Yes, my lords.
Yes. This is about 86A3.
Yes. Well, so far as liability which has been fastened upon me, let's everything against me.
State Council. You are going to ask the State Council as to how you are continuing with the blocking of the ITC beyond a period of 1 year.
And Millets, only one paragraph from the counter affidavit which they have filed. If I can just place, Millets, the last counter affidavit, supplementary affidavit which they have filed. Page 6, paragraph 9, Millets.
Initiated the process of unblocking. That Mrs. Mishra.
That's a very vague reply. For almost 2 years they have blocked it, and now when the final hearing is taking place, they file that we have initiated a process.
Yes, Mr. Mishra, what about?
My lords, regarding the maintainability, my lords, just 2 dates, my lords. And my lords would not like to entertain this writ petition, my lords, according to my humble submission, my lords. My lords, the impugned
I
order
have not yet completed, sister. I have not yet completed.
So we have put a question to her. She wants to add something more.
Well, it's only one provision I wanted to show, my lords. Only one provision.
We'll
Subject to
come
my
back.
lord's permission. Okay,
We'll come
as my lord pleases. As my lord pleases.
Yes.
My lords, impugned order is dated 18th of September 2019, my lords.
Yes.
And on on that day, DRC 7 was issued, my lords, pursuant to the order dated 18/9/2019, my lords. They had the occasion, they could prefer an appeal within 3 months, my lords, which expired in December 2019, my lords.
Not against DRC 07 alone.
My lords, the order was passed, my lords. It is evident from the perusal of DRC 7, my lords. The order dated 18/9/19. My lords, and they have never applied for the certified copy, my lords, of the order, which they could have done. My lords, order has been passed, which is part of the entire order sheet, my lords.
So you don't have to serve the copy of the order formally.
My lords, what instructions I have, my lords, is that they upload it on the website, my lords, and if they apply for a certified copy, they get the order, my lords. Only the summary is required to be uploaded, which is visible to them, which is visible to the SSC, which is DRC 7, my lords.
So after the summary was uploaded, they never applied for the certified copy. That is what you
Nothing, my lords, nothing. And my lords, the perusal of DRC 7, my lords. My lords, that will show, my lords, that order has been passed on 18/9/19, my lords. In fact, the case number is also given, my lords. My lords will find DRC 7 at page number 62, my lords. My lords, the case number is 11/18/18/19. Order date 18/9/19. Tax period July 17, September 18. So, my lords, an order has been passed, the summary of which has been uploaded in DRC's 07, my lords. And then, my lords, they had time to go prefer an appeal within 3 months, my lord. They missed the bus. They did not file any appeal, my lords, in December 2000 till December 2019, my lords. After almost a year, my lords, on 8th of October 2020, my lords, this writ petition has been filed, my lords. And my lords, it is well settled, my lords, that a writ petition is to be entertained, my lords, may be entertained during the period of the statutory period of appeal or revision, whatsoever it may be, my lords. For this, my lords, I am relying on the judgment annexed by my learned friend in the compilation, my lords, at page number 98, my lords. This is
we are aware of that.
My lords, and my lords, page para 15 of that order, my lords. My lords, the last part, my lords, which my lords will find at page number 111, my lords. However, if the writ petitioner chooses to approach the High Court after expiry of the maximum limitation period of 60 days prescribed under Section 31 of the 2005 Act, my lords, here it was Andhra Pradesh Act, the High Court cannot disregard the statutory period for redressal of the grievance and entertain the writ petition of such a party as a matter of course. Doing so would be in the teeth of the principle underlying the dictum of a 3-judge bench of this court in Oil and Natural Gas Corporation Limited. In other words, the fact that the High Court has wide powers does not mean that it would issue a writ which may be inconsistent with the legislative intent regarding the dispensation explicitly prescribed under Section 31 of the 2005 Act. That would render the legislative scheme and intention behind the stated provision OTOs. So, my lords, my humble submission is, my lords, that this writ petition is not maintainable. And otherwise also, my lords, on merits also, they do not have a case. Instead of preferring an appeal, they file a rectification application, which the section itself says that if there is a mistake apparent on the face of record, then the adjudicating authority has to take steps, my lords. My lords, admittedly, the reconciliation statement has been filed after the passing of the order of 18th September, my lords. So, my lords, there was no occasion that the reconciliation could be made at the time of passing of the orders, my lords. So, rectification application, my lords, is totally uncalled for. They could not have filed it. If they have filed it, they should not have waited for 6 months. And, my lords, after waiting for 6 months also, they could have preferred an appeal or by my lords, and they could have taken steps towards filing of the writ petition, but they did nothing, my lords. And my lords, now they have missed the bus regarding appeal, my lords. And my lords, regarding the merits, my lords, they say that their case is covered by NCAS, my lords. Just one provision, just one. My lords, first of all, in NCAS services, my lords, the show cause notice under section 73 was under challenge, my lords. And then on perusal of the show cause notice, my lords had come to the conclusion that it is not a valid notice, my lords. Neither there is a prayer for saying that the notice was not proper, and nor they have annexed the show cause notice, my lords, in their writ petition. They come with this plea only in the rejoinder, my lords. And my lords, page 27 of the compilation, my lords, para 14 of the judgment of NCAS, my lords, passed by my lords. My lords, the last paragraph, my lords, before the quotation, my lords. In this regard, it is profitable to quote the opinion of the apex court in the case of Oryx fisheries, in which, my lords, the Khemchand Constitution bench was quoted, my lords. My lords, expressions like a reasonable opportunity of making objection or a reasonable opportunity of defense have come up for consideration before this court in the context of several statutes. The constitution bench of this court in Khemchand versus Union of India, of course, in the context of jurisprudence, reiterated certain principles which are applicable in the present case also. S.R. Das, Chief Justice, speaking for the unanimous constitution bench in Khemchand, held that the concept of reasonable opportunity includes various safeguards, and one of them, in the words of the learned Chief Justice, is an opportunity to deny his guilt and establish his innocence, which he can only do if he is told what the charges leveled against him are and the allegations on which such charges are based. My lords, ample opportunity was granted to him, my lords, in the inspection which was carried out, my lords. The inspection report, my lords, the clear version is there, my lords, with my annexed with my counter affidavit, my lords, annexure A, my lords. My lords, if my lords will kindly take this annexure, my lords, annexure A at page 14 of my counter affidavit, my lords. This is the Janch Prativedan, my lords. Under what circumstances, my lords, this Janch was conducted, my lords? निर्देशानुसार उपरोक्त व्यावसायिक प्रतिष्ठान के दिए गए पता पर व्यवसायी द्वारा GSTR 3B 0 दाखिल किए जाने के कारण की जांच हेतु गए व्यवसायी अंचल में जुलाई 17 से आज दिनांक तक 0 विवरणी दाखिल कर रहे हैं, जबकि इनके द्वारा दाखिल GSTR 2A में ITC अवधि 17-18 में जुलाई 17 से मार्च 18 तक निम्नवत पाया गया. My lords, everything, the details of GSTR 2A, everything is given, my lords. They cannot say that there was no occasion for them to deny these allegations, my lords. फिर नेक्स्ट पेज में, my lords, वित्तीय वर्ष 17-18 में व्यवसायी द्वारा आउटवर्ड सप्लाई 0 दाखिल किया गया है, एवं इसी तरह 18-19 में भी आउटवर्ड सप्लाई 0 दाखिल किया गया है. विभागीय सॉफ्टवेयर से प्राप्त आंकड़े के आधार पर दाखिल GSTR 3B के आधार पर वित्तीय 17-18 में व्यवसायी द्वारा किए गए ITC का ब्यौरा निम्नवत है. विभागीय सॉफ्टवेयर से जांच आंकड़े में व्यवसायी द्वारा दाखिल GSTR 2A तथा ITC के आंकड़े में भिन्नता पाई गई. इससे संबंधित लेखा पुस्तकों की मांग की गई, जिसे उपस्थित व्यक्ति द्वारा अहमदाबाद के हेडक्वार्टर में संधारित रहने के कारण तत्काल उपस्थित करने में असमर्थता प्रस्तुत किया. यह झारखंड इतना के नियम 56 के अनुरूप नहीं है, अतः व्यवसायी को झारखंड माल एवं सेवा कर अधिनियम 17 की धारा 71 के अधीन दिनांक 4/12/18 को समस्त लेखा पुस्तकों के साथ राज्य GST उपायुक्त दक्षिणी अंचल के कार्यालय में समय 11 AM बजे उपस्थित होने का निर्देश दिया जाता है. My lords, this inspection report has been signed by the representative of the petitioner, my lords. At the left side, my lords, will find Prabha Energy Private Limited. So it was conducted in the presence of the representative, and the inspection report was handed over to him also, my lords. And then, my lords, from the entire order sheet, my lords, it is very clear, my lords, that 1/12/18 को inspection हुआ था और 4/12 को उनको प्रस्तुत करना था, which my lords, which is evident from their a few of their letters that they have produced certain documents, my lords. And my lords, later in this order sheet, my lords, at page number 19 of the counter affidavit, my lords, on 18/9/19, my lords, the order has been passed, and my lords, pursuant to that, the summary has been uploaded in GSTR 07 in DRC 07, my lords.
Yes.
My lords, reasonable opportunity, and now, my lords, they cannot raise the plea of principles of natural justice, and my lords, and they cannot put life in a dead horse, my lords. They have missed the bus of preferring an appeal, and now, my lords, my humble submission is, my lords, that this writ petition may not be entertained, my lords. Well,
It's a very short reply to what my learned sister has said, and I really thank her for taking my lords to the entire order sheet. If my lord comes to the order sheet for a moment, which starts from page 17. Of the counter affidavit, my lords. Page 17 of the counter affidavit.
Yes.
Well, it's the proceeding initiated at 1/12/2018 on which a inspection is carried out. Now, it's one by one I'll reply. My learned friend said that on the date of inspection, I was aware of what all violations I have done. Well, it's not a single provision under the entire act that on the day of inspection, I have to give any reply. First, 4/12/2018, I am called to furnish details. I furnish my details on 13 and 14/12/2018, not disputed. Then on 29, and my lords may simultaneously see the order sheet, my lords. 4/12/2018, the date is fixed. Then 8/12/2018, the date is fixed. The next page, my lords. 20th/12/2018, the date is fixed. I participate as per their version. I am also not disputing it. 31st/12/2018, date is fixed. I participate. 30th of January 2019, what is written, this is important, लोग. व्यवसायी द्वारा आईटीसी से संबंधित कागजात प्रस्तुत किया गया, आंशिक जांच पूर्ण एवं अगली तिथि 11/2/2019 निश्चित कर सूचना निर्गत करें. Now on 11/2/2019 oblique 22/7/2019, they issue me a DRC 07, it is 01, 02.
Yes.
The date is fixed for verification, inquiry, inspection of documents. And on the same day, they issue DRC 0102. And then next page, Manoj. 22/7/2019, they issue GST DRC 0102. I did not file any reply. No date of hearing fixed. And straightforward on 18/9/19, the order is passed. What is uploaded on the web portal is only the summary of order. No order is uploaded, which is mandatory. Which is mandatory. Or else my learned friend says that it is not mandatory. That is the first reply to the manner the proceedings have been carried out. Second, my learned friend says that from 18/9/19, 30 days is permissible. 90 days is permissible for filing an appeal. My lords, on 28/9/19, I file a rectification application. That is not entertained for 6 months, and my lords, I am equipped with the judgment of Honorable Supreme Court in the matter of MP Steel Corporation versus Commissioner Central Excise. My lords, this is reported in 2015, volume 7 SCC page 58. This takes care of the exigencies that if a petitioner has availed a wrong forum, in that event, the limitation will not come into picture.
Wrong forum means?
As my learned friend said, that he could have preferred an appeal. But what I did, out of bona fide belief, I filed a rectification application. They waited, they did not pass an order for 2 years, and before this honorable court, they are saying that no, rectification is not maintainable. Secondly, 6 months have already passed, hence we cannot pass any order. Now,
but that judgment of 2015, is it in respect of a quasi-judicial proceeding like the present one, or in respect of some proceeding before a court?
No, but it takes care of court also and quasi-judicial proceedings as well.
What does it say? You have not sent us the judgment.
Well, it's this issue they had not raised. This issue they had not raised. So that is why I had not forwarded it. Well,
And why did you sit for 1 year before preferring the writ petition?
well, it's from 23rd of March 2020. Well, there was a COVID. There was no work going on.
March came after 3 months of the expiry of the period of limitation.
No, but this petition was pending. Well, it's for rectification. 28/9/2019, I had filed it.
So how long, within how much period they are supposed to pass an order on
6
that?
months. 6 months they have to pass an order. If my lords would see section 161 for
They
a
have
moment.
already proceeded against you in a proper proceeding under section 73. 73 and 74 are the two proceedings for the respective violations, which are in substance the main proceedings.
Correct, my lords.
So being aggrieved by the outcome of the main proceeding in which you participated, you could have filed an appeal pending their response to the rectification petition. Both
I could not maintain a simultaneous proceedings. I cannot maintain a simultaneous proceeding, my lords.
No. Both the periods were also different. So you could have raised this issue in your appeal that the periods are also overlapping and I have filed an application for rectification.
Now, that is, I wanted to clarify that also, my lords. DRC 01, DRC 02, which has been issued on 22/7/20, I'm sorry, 22/7/19, this is issued on for the period for which the inspection was carried out. For the period the inspection was carried out, and DRC 07 also has been issued for the period the inspection has been carried out. And my rectification application, which they say is not maintainable or whatever, they could have at least passed an order. And it's a settled principles of law that until and unless, after GST Act has come into picture, until and unless an order is communicated to me, not the summary of order, proper order is communicated to me, the limitation will begin from the day the order will be communicated. That apart, if my lords would take up my compilation, Rule 142, what does it say, my lords?
Yes, 140.
142 at page 19, my lords.
Yes.
May I place it, minutes? The notice and order for demand of amounts payable under the Act, the proper officer shall serve along with the notice issued under section 52 or 73 or 74, 76, such and such, or a summary thereof electronically in form GST DRC 01. Statement under subsection 3 of section 73 or subsection 3 of section 74, a summary thereof electronically in form GST DRC 02, specifying therein the details of the amount payable. The proper officer, before service of notice to the person chargeable with tax, interest and penalty under subsection 1 of section 73 or subsection 1 of section 74, as the case may be, communicate the details of any tax, penalty and interest as ascertained by the said officer in part A of form GST DRC 01A. This has never been done.
इनिशियल वाले में सही मिस्टेक थोड़ा सा भी पुटिंग पे है क्योंकि वो लोग कहते हैं 6 महीने का टाइम you should have Mrs. Mishra, so far as the rectification application is concerned,
My lords.
that was made within the time permissible under section 61. You
Yes.
have not disposed it of within the time permissible to you to dispose it of. Can you take a plea now that it is not within your scope to or within the time limit to entertain that petition? That petition is pending before you. For inaction, you have allowed it to remain pending.
My lords, may I submit, my lords?
Yes.
My lords, this rectification application under 161, my lords, is not maintainable, my lords, because of the fact that, my lords, that it is maintainable only where the error is brought to its by.
That is okay, but
when the fees,
you should pass an order. You should
my
have
lords,
passed.
my lords, if it is not maintainable, my lords, where is the legal obligation, my lords, to
So you see,
pass an order,
if
my lords?
it is not maintainable, do we not pass any orders holding that it is not maintained?
Yes, my lords.
And you have issued ASMT 10 asking them to remove or explain the discrepancies. So then the notice, the initiation of that section 61 proceeding has taken off. And that has to be taken to its logical end. You ask for an explanation, they give some kind of an explanation.
Then you have to pass an order.
Then you have to entertain it and dispose it of. If whether it is permissible or it is in the nature of a review, you have to pronounce your mind upon that.
Yeah, because you have already initiated by asking documents.
And that application, you need not have issued a ASMT 10 at all. The slate would have been very clear. You have yourself issued ASMT 10 and carried on with the proceeding under this section 73 based on an inspection. So he gets an opportunity to seek a rectification.
My lords, may I submit, my lords? ASMT is, my lords, only for the period 18-19, my lords. For the period 17-18, my lords, there is no SMT 10, my lords. My lords, and the DRC 7 has been also, DRC 01 and 02 is also for the period 17-18, my lords.
Up to September 2018.
Yes, my lords. Yes.
There is an overlapping period. Overlapping periods are there.
Don't confuse us now. These dates are so confusing that every time one tends to miss them. 1st July to September 18 is the DRC 01 and 02.
Yes, my lords.
ASMT 10 is April 18 to March 19. So they are overlapping. Overlapping for the period April 18 to September 18. And the supplier perhaps may not have given the details of the tax received or debit notes, invoices, etc., so that its GSTR2A was not auto-populated. And that is, and taking note of all those handicaps, the extension of time for uploading those things was given up to March 2019. So these things he is trying to explain for seeking a rectification. We will not conclude it today because time is running out and there's some other administrative works also. So,
Can I, subject to my lord's permission, can I make a suggestion, my lords?
What?
My lords, admittedly, my rectification application is pending till date.
6 months.
If I am allowed, my lords. The end of 6 months.
You have not taken any decision within 6 months.
Now, my lords, 6 months is ending during the COVID period. 6 months is ending during the COVID period. Now, as per the judgment of Supreme Court in court on its own motion, it is extended until the 28th of February 2022. Now, I am before my lords during this period. If my lord gives one opportunity to either of the parties, Well, I'll appear with my books of accounts, everything. They can take a decision on my rectification application.
Just think over it, Mr. Mr. Time is running out for you also and for them also. That outer limit of 28th February has already run out, but of course, the period which falls within the total period of exempted period of delay from March 2020 till say February 2022, that will extend to the benefit of the person who has to comply. So think over it. We will take it up on the next Wednesday. And on this section 161 application, your officers perhaps are operating under an impression that the time period has run out and therefore they could not entertain it. And apart from that, it amounts to a review kind of thing. But then you have to dispose it of either way. And if you dispose it of either way, there could lie an appeal against that also.
Yes, Manoj.
So there's a thin window for the petitioner. Let it continue for next Wednesday so that you can be ready on this aspect also.
Manoj.
Manoj, can I pray for Monday, Manoj? Because time is running against either of us, Manoj.
That depends. The AG1, how much time she will take.
Manoj, this matter may not take much time, Manoj.
Too many matters on Monday.
And Manoj, in fact, in one of the matters which I have done recently with the commercial.
Tuesday,
Manoj. Tuesday. Much obliged, Manoj.
Much obliged, Manoj.
When counsel for the parties have advanced their submissions for further submissions towards the matter on 8th March 2020.
Much obliged, Manoj.
Obliged, Manoj.
Item WPC number 1, 336 of 2013. Mr. Rakesh Marai for the petitioner.
We are going to rise. This will continue on the list. Hearing matter. Who has filed an IA? Union of India.
Lords, petitioner has filed the IA, Lords. Mr. Mahesh Tiwari has filed IA to bring on record certain documents. IA to bring on record certain documents which has not been filed with the writ petition, Lords.
Email filing has not come on record. We only received an intimation that it has been filed. Tell them to file in between.
Yes, my lord, we have filed.
Okay. We'll take it up on the next Wednesday.
My lord.
Obliged.